Started recording now. My name is Danielle Conway. I'm the proud dean of the University of Maine School of Law, and I'm even prouder because today we are actually recognizing Constitution Day. Constitution Day was actually September 17th, but we're recognizing it today with a formal program. The reason we are doing this is because we are a federally funded university, but the real reason we are doing this for the 9th year in a row is because we at the law school believe in the document, the wondrous document called our United States Constitution. There are those that would even challenge the requirement to have a Constitution Day if one is receiving federal funds. Well, we don't challenge that here because what we are teaching day in and day out is that this wondrous document is responsible for our organized and civilized society. It makes us who we are, the 320 million of us who live in the boundaries called the United States. It allows us to coexist, to learn, to educate ourselves about our environment and our community. This is a wondrous and reverent document, and we are so proud to honor it today at Constitution Day. I want to recognize the senior leadership team of the University of Southern Maine to my left, and please give them a hand. When I said that we had Constitution Day and we had to deliver this programming, they said, we are here and we will actually attend your Constitution Day. And that is directly because of the leadership of President Glenn Cummings. Would you stand and be recognized? I also want to take this opportunity to recognize not only current faculty and staff at the University of Maine School of Law, but also former faculty who are here visiting with us. Please stand. Thank you for actually attending this program, and thank you for honoring the Constitution. I now introduce you to the Chief Academic Officer, Associate Dean of Academic Affairs, and Professor of Law, Jennifer Riggins.
So we are delighted to welcome the Honorable Kermit Lipez, Judge on the First Circuit Court of Appeals, as our annual Constitution Day lecturer this year. Can everyone hear me? Judge Lipez has served as a judge on the Maine Superior Court, on the Maine Supreme Judicial Court, and now on the Federal First Circuit Court of Appeals in Boston, Massachusetts, to which he was appointed in 1998. He went on senior status in 2011, but remains hard at work. He is a revered judge, respected widely for his insightful, well-crafted, and bold opinions in a host of areas, many related to constitutional law. For example, wiretapping and affirmative action. He has welcomed and mentored many Maine law students as judicial externs, and several have served as his clerks. He has taught at Maine Law and elsewhere, and has written widely in addition to his many judicial opinions. A book chapters, and many law review articles, including on the First Amendment to the U.S. Constitution. Before becoming a judge, he was in the United States Department of Justice Honors Program as a staff attorney in the Civil Rights Division. He then served as legal counsel to Maine Governor Ken Curtis and was a legislative aide for U.S. Senator Ed Muskie. He also was in private practice in Maine for several years and attended Haverford College and Yale Law School. For 7 years, in addition to his full-time judicial responsibilities on the First Circuit Court of Appeals, he chaired the Justice Action Group. This is a statewide, judge-led coalition of leaders in Maine's legal community, with a goal of increasing and coordinating free or reduced rate civil legal services to low-income people in our state. Maine Law, of course, is an active participant in this group through our clinical programs and other work. And Judge Lipez's outstanding efforts have helped thousands of people gain access to justice all across the state. We are very grateful that he has agreed to give the Constitution Day lecture today on the topic of the police, the First Amendment, and the digital age. Please join me in welcoming Judge Kermit Lipez.
Professor Riggins, Dean Conway, thank you for those very kind remarks. It's a pleasure to be here with all of you today to celebrate our Constitution and the rule of law. I have enormous admiration for this law school. As Professor Riggins mentioned, I have worked with many of the students over the years and many of the faculty members. My wife, I should add, who is with me here today, is a proud member of the class of 1980. By her account, the best class to ever graduate. And I am very grateful for the invitation to speak here. Can you all hear me? Great. I've had the privilege of being a judge for over 31 years on trial and appellate courts, state and federal. To date, I have written over 1,300 opinions. Although I believe that all of those opinions are important, some have gained more prominence than others. I want to talk about one of those opinions today. A 2011 decision that involves the First Amendment, the complex relationship between the police and the communities that they serve, and the revolution in communication technology. Before getting to the substance of my remarks, I want to emphasize 2 points. Although some might consider them incompatible, I do not. I have enormous respect for police officers and the work that they do. Their lives are at risk every day. We have seen that reality far too often in recent months. We should be grateful to police officers who go to work despite these risks. But I also support close scrutiny of the work of police officers. I believe we can honor the work of the police while still acknowledging the need for that scrutiny, and I hope to provide that balance in this talk. The story begins on the Boston Common, the oldest public park in America. The British Redcoats began an 8-year encampment there in 1768. The colonial militia mustered there on the eve of the American Revolution. George Washington, John Adams, and General Lafayette visited the Common to celebrate our nation's independence. In the 1860s, anti-slavery meetings took place there. Anti-Vietnam War and civil rights rallies were held on the Common, including one led by Dr. Martin Luther King. In 1979, Pope John Paul II celebrated Mass on the Common. Protests of one kind or another continue to be held there. It is a quintessential setting for the exercise of free speech and public assembly. On the evening of October 1, 2007, Simon Glick was walking past the Common. Born in Moscow, Glick moved from Russia to the Boston area in 1993 and subsequently attended the New England School of Law, where he graduated first in his class in 2006. After working as a law clerk for the Massachusetts Probate and Family Court, he opened a solo practice in Allston, Massachusetts, specializing in immigration law, civil litigation, and criminal defense. On his website, he tells prospective clients that, and I quote, "I try hard to achieve justice in every case for every client, because I believe the rule of law is designed to protect the weak against the powerful. I personally have experienced what it is like to be unjustifiably accused by the government, so I'm prepared to fight for my client in each and every case." Glick was, in fact, unjustifiably accused by the government of criminal offenses because of an incident that occurred on the Boston Common during his walk that October evening. He noticed 3 police officers arresting a young man on the Common. Then he heard a bystander say, "You are hurting him, stop." Concerned that the officers were using excessive force to make the arrest, Glick stopped roughly 10 feet away from the officers and began recording video footage of the arrest on his cell phone. After placing the suspect in handcuffs, one of the officers turned to Glick and said, "I think you have taken enough pictures." Glick replied, "I am recording this. I saw you punch him." An officer then approached Glick and asked if his cell phone recorded audio. When Glick said yes, the officer arrested him for unlawful audio recording in violation of the Massachusetts wiretap statute. Glick was taken in cuffs to the South Boston Police Station. In the course of booking, the police confiscated Glick's cell phone and a computer flash drive and held them as evidence. Later, the police added to the wiretap charge disturbing the peace and aiding in the escape of a prisoner charges. The prosecution did not go well in the Commonwealth. It immediately dismissed the charge of aiding in the escape of a prisoner, acknowledging lack of probable cause. In February 2008, in response to Glick's motion to dismiss, a Boston municipal judge disposed of the disturbing the peace charges, ruling that the fact that, quote, "the officers were unhappy they were being recorded during an arrest does not make a lawful exercise of a First Amendment right a crime." The judge also dismissed the wiretap charge, finding no probable cause to support it. The law requires a secret recording, and the officers admitted that Glick had used his cell phone openly and in plain view to obtain the video and audio recording. Glick then filed an internal affairs complaint with the Boston Police Department, but the department declined to investigate his complaint or take any disciplinary action against the arresting officers. That stonewalling by the department prompted Glick to file a civil rights lawsuit against the arresting officers and the city of Boston in February 2010 in the Federal District Court in Boston, claiming violations of his First and Fourth Amendment rights. Relying primarily on the doctrine of qualified immunity, which I will explain shortly, the defendant officers moved to dismiss the complaint because, in their words, and I quote, "It is not well settled that Glick had a constitutional right to record the officers." The district court denied their motion, concluding that in the First Circuit, the First Amendment right to publicly record the activities of police officers on public business is established. The defendants immediately appealed. Glick's lawyer enlisted the support of the ACLU of Massachusetts to protect the district court's ruling. We also received amicus briefs on Glick's behalf because of the high stakes in the appeal. Although Glick's Fourth Amendment claim was important, it turned on the particulars of the Massachusetts wiretap statute. Glick's First Amendment claim, that he had a right to record the arrest on the Boston Common, had much broader implications. On appeal, the Boston police officers continued to rely on the difficult doctrine of qualified immunity. If I had to identify one issue that has consumed more of my time than any other on the Court of Appeals, it would be qualified immunity. The purpose of the doctrine can be simply stated. It is a defense that protects government officers from damages liability and often from the trial itself. It balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. The doctrine poses two questions. First, whether the facts alleged by the plaintiff make out a violation of a constitutional right. Second, whether that right was clearly established at the time of the defendant's alleged violation, such that the officer should have known that what they did was wrong. If either question is answered no, the defendants are entitled to immunity. Thus, the clearly established question adds another layer of protection for government officials. If the law was not clear, we do not want to penalize them for taking actions they reasonably could have believed were proper. The second question, the clearly established question, accounts for much of the difficulty in qualified immunity cases. The analysis must be situation specific. When an officer confronted with the particular facts alleged by the plaintiff have understood that the conduct at issue violated an individual's constitutional right. Without that specificity, the theory goes, government officials will not have fair warning that they are behaving unlawfully. That fair warning comes from judicial precedents establishing constitutional rights. This requirement accounts for another challenge in qualified immunity law. The temptation for judges to avoid answering a difficult constitutional question when it is easier simply to say that the constitutional right was not clearly established at the pertinent time. In other words, if the right being claimed by the plaintiff was not clearly established when the government officials acted, those officials are entitled to qualified immunity even if the judges concluded that their behavior violated the plaintiff's constitutional rights. Avoiding the constitutional question makes some sense if the judges on a panel disagree about whether a constitutional violation occurred, but do agree that the right was not clearly established at the relevant time. It is a prudent use of judicial resources to choose the consensus course. On the other hand, if judges constantly avoid the underlying constitutional question, clearly established law will never develop. Aware of the two-pronged qualified immunity inquiry, the police officers in Glick urged us to hold that any right to film police carrying out their duties in public, if it existed, was not clearly established when Glick was arrested. My colleagues and I rejected that approach. We understood the importance of first answering the constitutional question. By its terms, the First Amendment's prescription on the laws, to quote the First Amendment, abridging the freedom of speech or of the press, says nothing about the gathering or dissemination of information by the public. But the Supreme Court had long ago established that the First Amendment goes beyond protection of the press and the self-expression of individuals to prohibit government from limiting the stock of information from which members of the public may draw. Relatedly, there is an undoubted right to gather news from any source by means within the law. With these principles in place, and citing cases from 2 other circuits supporting Glick's claim, we concluded that, quote, the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within these principles. Noting the temptation of governmental authorities to repress or discourage opposition, we observe that this temptation is particularly true of law enforcement officials, who are granted substantial discretion that may be misused to deprive individuals of their liberties. The ability to collect information about their work could discourage such abuses. Then, again drawing on precedent, we made the important point that the public's right of access to information is coextensive with that of the press. Indeed, in an observation confirmed by current events, we said that changes in technology had blurred the lines between private citizen and journalist. To quote our opinion, the proliferation of electronic devices with video recording capability means that many of our images of current events come from bystanders with a ready cell phone or digital camera, rather than a traditional film crew. And news stories are now just as likely to be broken by a blogger at a computer as a reporter at a major newspaper. Having decided that Glick had a First Amendment right to record the arrest on the Boston Common, we then had to decide if the law supporting that right was clearly established at the time of his arrest in the First Circuit. The First Circuit, by the way, includes Maine, Massachusetts, Rhode Island, New Hampshire, and Puerto Rico. As you might expect, there is an important connection between the constitutional question and the clearly established question. If there is abundant law supporting the conclusion that the conduct of government officials violated the Constitution, the clearly established question becomes much easier to answer in the affirmative. I would not say that we found abundant law in Glick supporting the right to record. There were the general First Amendment principles I have mentioned about the right to gather information on the work of government officials, available both to journalists and private citizens. There were the two Court of Appeals decisions concluding a scant analysis that an individual has a First Amendment right to record police conduct in public places. And importantly, we had a First Circuit precedent that said, again with scant analysis, that a self-styled journalist arrested for filming members of a local commission in the hallway outside a public meeting had been exercising a First Amendment right to film. Although the appellants had cited two other Court of Appeals decisions holding that the right to film the work of police officers in public was not clearly established, one of those opinions was an unpublished per curiam with no precedential force, and the other involved a traffic stop characterized by the court as an inherently dangerous situation. That description did not apply to the arrest on the Boston Common. So, the question is whether these pieces of law would give reasonable police officers in the First Circuit, confronted with Glick's videotaping, fair warning that he had a First Amendment right to film their conduct. If so, they would not be entitled to immunity for their unconstitutional conduct in arresting Glick. In answering this fair warning question, we found notable the brevity of the analysis in our First Circuit case and in the precedent of the other two circuits that agreed that the First Amendment provides a right to film the public conduct of government officials. As we saw it, quote ourselves again, this terseness implicitly speaks to the fundamental and virtually self-evident nature of the First Amendment's protection in this area. We also gave considerable weight to the clear language in our own precedent, which stated that because the plaintiff's journalistic activities, quote, were peaceful, not performed in derogation of any law, and done in the exercise of his First Amendment rights, the officer lacked the authority to stop them. We therefore disagreed with the Boston police officer's assertion that at the time of Glick's arrest, there was no clearly established First Amendment right in the First Circuit to record police officers carrying out their public duties. Rather, our own precedent and the self-evident nature of the First Amendment right at issue led us to conclude that, quote, the state of the law at the time of Glick's arrest gave the police officers fair warning that their particular conduct was unconstitutional. There was immediate recognition of the importance of the Glick decision. The New York Times editorial board described it as, quote, a strong opinion, protecting the right to videotape the activities of police officers in public. It noted that the officers tried to turn Mr. Glick's exercise of his rights into a crime. By turning his cell phone camera on them, he held them accountable for their conduct. Within months of Glick's issuance, the Seventh Circuit, citing Glick in a lengthy decision, recognized the First Amendment right to record police conduct in public places. Law journals and media bloggers took note of Glick too, emphasizing its importance in establishing that there was now a clear constitutional right to record the public activities of the police. As one blogger put it, and I quote, the Glick case was sort of a turning point because it was a very clear opinion. The First Circuit really grounded its recognition of this First Amendment right in a long tradition of First Amendment activity in public places. And so it was a very powerful statement that, yes, we should be recognizing this right, and other courts started to pick up on that. There was also recognition of Glick's implications for the role of the citizen journalist recording the work of the police, a phenomenon that began as early as 2 decades ago with the police beating of Rodney King in Los Angeles. As some of you may recall, The video of that assault transfixed the country because of the brutality it recorded and its novelty. We only saw the beating because of the happenstance of a Sony Handycam, hardly a ubiquitous item, in the hands of a plumber who recorded the encounter and then, sensing the significance of what he had seen, sent his tape to a local television station. Glick, as we noted in the panel opinion, was decided in the smartphone era. As you well know, it is no longer happenstance that someone like Simon Glick has the tools needed to become a citizen journalist, exposing what he believes is police misconduct. The right to record articulated in Glick and the technology now available for the exercise of that right have fundamentally changed the nature of policing in this country. Traditionally, the police have not welcomed challenges to their authority. In his classic 1959 study of the exercise of police power in New York City, Professor Paul Chevigny of NYU Law School observed that any criticism on the street of a policeman's conduct was invariably interpreted as an offensive challenge to the officer personally as well as to his authority. If an agitated citizen visibly wrote down an officer's shield number, the result was often an arrest for interfering with a police officer or disorderly conduct. What happened to Simon Glick on the Boston Common was a modern-day version of that phenomenon, the invocation of a wiretapping statute to deter the use of modern technology to record the work of the police. We described in Glick the substantial discretion granted to police officers. As one scholar has put it, and I quote, "Police work remains essentially reactive, essentially unsupervised at critical moments, and essentially dependent upon the judgment of the officer on the scene." As the same scholar observes, this discretion makes the work of police morally taxing, in the sense that the justification for the exercise of authority is often ambiguous. Even the issuance or non-issuance of a parking citation can become a moral question for a police officer. Is the officer being even-handed? Should he recognize extenuating circumstances? Should he give someone a break if it is deserved? Moreover, police officers are the public officials most likely to interact with the public, and our law empowers them to use force, sometimes even deadly force, in those interactions. Yet we also expect police officers to use force in a manner that complies with the law and the Constitution. Put differently, we expect the police to maintain order through coercive force on the one hand, and on the other, to respect the rule of law, individual rights, and the limits of government authority. We understand that the police must often make judgments about the use of their authority under difficult circumstances. We understand the moral dilemmas that they sometimes face in making their decisions, but the stakes in their exercise of judgment are so great that we as citizens must insist that their word receive public scrutiny. In Glick, we acknowledge both the burdens of the scrutiny for the police and its importance for our way of life. Police officers, we said, are expected to endure significant burdens caused by citizens' exercise of their First Amendment rights. Indeed, the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. The same restraint demanded of police officers in the face of provocative and challenging speech, we said in Glick, must be expected when they are merely the subject of videotaping that memorializes without impairing their work in public spaces. I must acknowledge that I now read with some uneasiness this statement in Glick that officers will now be merely the subject of videotaping that memorializes without impairing their work in public spaces. The focus of that statement was videotaping that records without impairing the performance of the duties of the police officers in circumstances comparable to Glick's arrest. Any discomfort that the police feel at being recorded in such circumstances does not qualify as impairment. In this limited sense, the reference to mere videotaping was not problematic. But that reference does understate the power of images seen widely to magnify the consequences of one incident for the police and the public. Although this power of magnification does not affect the validity of the legal analysis in Glick, it affects dramatically the significance of the decision. Most notably, we see that significance in the intense debate over policing in black communities. The filming of police conduct has brought a new urgency to that long-simmering issue. In the black community, as one reporter put it, the close-up views of violence, obviously traumatizing, are giving rise to a generation of young people who distrust authority, grow up well before their time, and suffer nightmares that seem too real. In light of this distrust, Representative James Clyburn of South Carolina, one of the most prominent political figures in the state, has urged young black individuals to, quote, keep your cell phones tuned up, keep the battery charged, and don't hesitate to turn them on if that's what it's going to take for police officers to really think twice before pulling their weapons. There are now phone applications with names like Cop Watch, I'm Getting Arrested, and Stop and Frisk Watch, with easy recording and upload capabilities so that, according to the promotional material, you don't have to fumble around with your device. Also, with the introduction of tools like Periscope and Facebook Live, video can be streamed even before an encounter is over, leaving no time for investigations or official statements. The technology allowing citizens to record and publish events instantaneously has advanced markedly since the issuance of Glick 7 years ago. Not surprisingly, many police officers feel besieged by these capabilities. One officer in Los Angeles observed that, quote, anytime there is a traffic stop made, the cell phones come out. The people taking them out have nothing to do with the incident, but they feel they need to videotape it. It's like they think, I'm not going to stand across the street, I am going to become part of the problem. Also, the police warn that a video does not always tell the full story. As they say, it can't be viewed as DNA, it doesn't have that level of conclusiveness. Yet the power of a video of a police-involved shooting is undeniable. Drawing on a wartime analogy, one officer observes, I think a lot of what people see creates shock and awe. For many of the nation's 800,000 state and local law enforcement officers, there is presently a wartime feel to their work. Even the most hardened veterans call this one of the most charged moments of policing they have experienced. The power of filming police conduct also has enormous courtroom implications. Traditionally, trials have been the recreation through courtroom testimony of an event that occurred in the outside world. Although testimony remains important, digital recording can bring that outside event directly into the courtroom to support or contradict the testimony. For a long time, commentators have noted that juries often exhibit a significant bias in favor of a police officer's version of events over that of a civil rights plaintiff or a criminal defendant. But video footage often goes a long way in narrowing or eliminating this built-in credibility gap. Put bluntly, in some cases, as one commentator noted, a camera can mean that there is no ambiguity about what happened. Given these realities, the omnipresence of video technology and its power, many police departments have moved from resisting recording of their conduct by citizens to a growing willingness to place body cameras on themselves. One study indicates that body cameras, or in official jargon, on-officer recording systems, are now used by about 25% of police agencies in the United States, and 80% of these agencies are at least evaluating their use. Police unions have generally not opposed body cameras, believing that they might help the police defend against unfounded citizen complaints, and may often exonerate police officers rather than implicate them in misconduct. President Obama announced in December 2014 a $263 million program to purchase body cameras and improve the training of police officers who would use them. To be sure, there remain thoughtful dissenting voices on the use of body cameras. There are serious privacy concerns for people who unwittingly, and perhaps with no involvement in the incident being investigated, are revealed on a widely distributed video. Some police officers worry that cameras will inhibit victims and witnesses from speaking freely to the police, particularly in cases of sexual abuse or assault. With body cameras in greater use, judges and juries will expect video footage of incidents, and when no footage is available, the officer's integrity might be questioned. Then there are the continuing concerns for officers posed by body cameras. As one police officer put it, "I pity the first officer with a body camera who forgets to turn it on or is shot because their decision to turn on the camera slowed their application of force." There have already been studies on the impact of the use of body cameras. Somewhat surprisingly, in a just completed study, the RAND Corporation reports that rates of assaults against officers wearing cameras on their shifts were an average of 15% higher compared to shifts without cameras. The authors of the study suggest that this unexpected result may be due to officers feeling more comfortable reporting assaults once they are captured on camera. Also, they suggest monitoring by camera may make officers less assertive and more vulnerable to assault. Other studies suggest that these increased assaults against police officers could be avoided if the officers notified civilians that their conduct was being recorded by a body camera. That notification may encourage compliance with the orders of officers, even by highly agitated people, and promote more peaceful interactions with the public. As for the use of force by the police, the RAND study found that if officers turned cameras on and off during their shifts, use of force increased. If they kept the cameras on for their whole shifts, use of force decreased. Perhaps anticipating such a finding, the ACLU report that calls for continuous recording throughout a police officer's shift to eliminate any possibility that an officer could evade the recording of abuses committed on duty. Yet, the ACLU acknowledges its concerns about the increasing use of surveillance video in our society, and continuous recording raises privacy issues for the public as well as for officers. On balance, though, weighing the importance of police accountability against the privacy interests of citizens generally, the ACLU has concluded that the balance tips heavily in favor of body-worn cameras. Ideally, the ACLU says, there would be a way to minimize data collection to only what was reasonably needed, but there is currently no technological way to do so. Given these technological and policy issues, the debate over the use of body cameras will continue for some time. Also, more studies will and should be done on the effect of body cameras. The study results that I have read seem preliminary and tentative, but there is little doubt that body cameras in some form will become an almost universal and routine part of police work. That is a remarkable revolution in the nature of police work in the 7 years since Glick was published. Interestingly, this revolution has occurred even though Glick and his 3 companion courts of appeal decisions are not the law of the land. Circuit courts announce law binding only in their circuits. The Supreme Court has not yet issued a decision applying the First Amendment to the filming of police conduct. So why has there been this wide acceptance of the right articulated in the Glick line of cases, even without controlling law everywhere? I think that the answer is twofold. First, there is a point that we made in Glick about the fundamental and virtually self-evident nature of the First Amendment's protections for our right to film the police carrying out their public responsibilities on our behalf. In a free society, it feels right that we can invoke this potent tool of accountability. Second, perhaps reflective of this feeling of rightness, there was a positive response to Glick in newspapers, blogs, and law journals that I have already noted. although I cannot cite hard evidence for this proposition. I think that reaction contributed to a sense that the First Amendment principle articulated in Glick is now a durable part of our law, and the public and law enforcement community may rely upon it and should adjust to it. I acknowledge that I take some satisfaction in this belief in the importance of Glick. I also think about the case every time I see another story about a highly publicized confrontation between the police and a member of the public, memorialized on film, whether by a witness with a smartphone or the police with a body camera. But I also acknowledge an unanticipated consequence of the Glick line of cases. The recording of police conduct, whether by a witness or the police themselves, has inflamed the debate over the racial divide in this country, sometimes with tragic consequences. So we must face a hard truth about policing in the digital age. Although we must honor the vast majority of police officers who do their difficult work well, we must also recognize that Black people experience the criminal justice system, including police interactions, differently from their white neighbors. I give you one recent example. In August, the United States Department of Justice issued a report of its investigation of the Baltimore Police Department in the aftermath of the death of 25-year-old Freddie Gray while in police custody. The investigation showed a significant racial disparity in arrests in Baltimore for highly discretionary offenses, such as failure to obey or trespassing. That finding reflects a presumption of criminal activity by Black males that Brian Stevenson, the head of Equal Justice Initiative, an organization dedicated to saving the lives of death row inmates, sees throughout our criminal justice system. As Stevenson puts it, and I quote, "Our society applies a presumption of dangerousness and guilt to young Black men, and that's what leads to wrongful arrests and wrongful convictions and wrongful death sentences, not just wrongful shootings of Black suspects. We have a long history of seeing people through this lens of racial difference. It's a direct line from slavery to the treatment of Black suspects today, and we need to acknowledge the shamefulness of that history." President Obama referred to the same presumption in his speech in July, honoring the 5 slain peace officers in Dallas. The president acknowledged that 50 years after passage of the Civil Rights Act, Black parents, wary of interactions with the police, still fear that something terrible may happen when their child walks out the door, still fear the kids being stupid or not quite doing things right might end in tragedy. But President Obama warned that this reality does not justify irresponsible condemnation of the police. With an open heart, said the president, those protesting for change will guard against reckless language going forward. Look at the model set by the 5 officers we mourn today. Acknowledge the progress brought about by the sincere efforts of police departments like those in Dallas, and embark on the hard but necessary work of negotiation, the pursuit of reconciliation. In my view, we can only achieve the reconciliation envisioned by President Obama if we both honor the work of the police and accept the legitimacy of grievances in the Black community about the misdeeds of some police officers. Hopefully, with powerful digital images now confirming those grievances and, in other instances, vindicating the work of the police, the right of individuals to record the public work of the police can help in the long run to bridge the differences between the police and the communities that they serve. In conclusion, I want to describe the aftermath of our remand of Simon Glick's case to the district court. The case never went to trial. Instead, the city settled with Glick for $170,000 to pay for his damages and legal fees. In the wake of that settlement, the Internal Affairs Division of the Boston Police Department, which initially refused to investigate Glick's complaint about his arrest, disciplined 2 of the officers involved in that arrest for using unreasonable judgment. The city also developed a training video based on facts similar to the Glick case, instructing police officers not to arrest people who openly record what they are doing in public. Boston Police Commissioner William Evans said of the training video, "It changes our training. It changes the way we advise officers to deal with the situation. It still doesn't give someone the right to interfere with the lawful arrest that's occurring." Subsequent to the development of the training video, Commissioner Evans announced in September 2015 that body-worn cameras for police officers were coming to Boston. In response, the legal director of the ACLU in Massachusetts stated, "It combined with a policy that follows three core principles, accountability, privacy, and transparency, body cameras can deter misbehavior on both sides of the badge." However, that body camera program, which was to begin with a pilot project involving 100 officers, was delayed because of resistance from the Boston Police Patrolmen's Association on collective bargaining grounds. After some recent court skirmishes between the association and the city, the pilot project has just begun. For Simon Glick, all of these developments had to be gratifying. Prior to his arrest in October 2007, an unknown number of individuals who had tried to record public conduct of police officers in Boston and elsewhere have been ordered to cease the recording or face arrest for the same spurious charges invoked against Glick. This time, however, the police had charged a defense attorney who knew how to respond. Glick had fairly stated on his law office website that he had experienced what it is like to be unjustifiably accused by the government. To his credit, with his challenge to that unjust accusation, he significantly enhanced the First Amendment rights of individuals in his adopted country by contributing to the clear establishment of their right to film the public conduct of police officers. Also, he confirmed for the law students in this audience a truth about the value of your law school education. It empowers you to do important work. Thank you.
So I want to allow for questions, and this is, you have to know, this is a difficult thing for any judge, particularly a circuit court judge, to do. So if you ask a question and he's not able to answer it, it's not because he's sidestepping, it's because he is in a very important position, and that position requires neutrality. But what I would like to do is recognize our high school students from South Portland and ask them to stand up and be recognized and ask them if they want to ask the first question. These students are part of our pilot Opportunities Through Law program that we've initiated at the law school. And so I want them to be able to ask the first question. No pressure. Yes, Cameron.
What made you want to start law in the first place?
Good question.
I'm sorry.
What made you want to start doing law, like being a lawyer, doing your venturing into that?
Why did I want to be a lawyer?
Yeah.
Well, it's both I guess a very personal reason and then maybe a larger, more abstract reason. My father was a lawyer, he was a judge, and I saw the satisfaction that that brought to him, so it struck me as a rewarding way of life. But I also wanted to do work that would allow me to perhaps foster some meaningful change, help me address problems that I thought were important. And as I suggested in these remarks, law does allow you to do the kind of work that can bring about important change. I was drawn to those possibilities, and I must acknowledge that I have never regretted my choice, and I think it's an honorable and important choice, and if you're interested in law, I encourage you to pursue it.
So I think we have time for 2 questions. First, Professor Donald Zillman.
Judge, did any of the police or their counsel argue that it would have been improper to simply observe rather than record the incident? In effect, try to disqualify their testimony at trial?
No, they never made any such argument. It was the fact of recording that provoked their strong.
So the potentially more accurate report of what happened is the wrong one.
That argument, that possibility did not occur to them.
And one last question. Yes, Isaac.
In relation to the recording of the body cameras on the police officer, you talked about it exonerating the police officers of their charges or something along those lines. It's obviously good PR to have these things, but where do we draw the line as far as publicizing those specific recordings? So in some instances, like in California, there was the fireman that was off duty, but he was going in there and they had the body camera and it somehow got released to the media. Like, what types of things are being put in place to maybe protect the public's privacy as well as the police officer's privacy? And then in addition, is it potentially going to turn into a situation where we have the battle of the videos, where the police are releasing videos, the public's releasing videos?
Well, those are all possibilities. You cite some of the downside of body cameras. They're not an unmitigated blessing. I think the concern of police officers when they're investigating assaults, sexual abuse cases, I think they worry quite legitimately that if individuals who might be forthcoming understand that they're going to be filmed, in effect, and the possibility that what is filmed will then become very public could deter cooperation in those kind of offenses. So there is a downside to body cameras, and that's why, as I suggest, there is a need to study them, and there are rules that will have to be put in place to control both their use and distribution.
So, Judge Lipez.
Yes.
One of the coveted Maine law bag with a single gift inside. But that single gift reflects our singular dedication to upholding the Constitution in your honor and the honor of those who wrote it. Thank you.